This is the appointed time and we have a quorum. I call the meeting to order. This is a subcommittee on proposed resolutions under the Bankruptcy Ordinance and the Companies Ordinance. This is our second meeting. Let's confirm the minutes of the last meeting first. Minutes of the meeting on the 19th of July 2013. The draft is CB bracket 11830/12 to 13. It's been given to members before the meeting. The Secretariat has not received any proposed amendments. I ask members to confirm the minutes. Thank you. This is a meeting with deputations. Shall we invite the administration to come in first? Now, let's invite the deputations to join us. We have with us from the administration, Official Receiver, Ms. Teresa Wong, Principal Assistant Secretary for Financial Services and the Treasury, Mr. Maurice Liu, and from the Department of Justice, Government Counsel, Ms. Cindy Chuk.
Please say that.
Welcome. Welcome deputations and the administration for attending the meeting. We're here to meet with deputations on the proposed resolutions. We have 3 deputations to give verbal submissions today. We have with us Caritas Family Crisis Support Center, Debt Counseling and Financial Capability Service, Center Supervisor Ms. Paulina Kwok. Caritas Family Crisis Support Center, Concern Group on Hong Kong Personal Credit Problem, Representative Mr. Kwong Chung Keung, and from the Hong Kong ICPA, Restructuring and Insolvency Faculty Chairman, and Restructuring and Insolvency Faculty Member. I'd like to remind deputations, what you say verbally and what you write in your written submissions are not covered by the Legislative Council Powers and Privileges Ordinance. I give 5 minutes to each deputation. You may use the earpiece. Channel 0 is the floor. 1 is Cantonese, 2 English. First, Ms. Kwok. Members, chairman, officials and officials. In the past 11 years, the service has helped over 60,000 debtors, one-stop service, one-stop counseling service. In most of the cases we have dealt with, the majority of the debtors come from grassroots. About 70% of them are low-income earners. 25% of them live under the poverty line. This is similar to the figures announced by the ORO, Official Receiver's Office. That is 77% of the people earn under $10,000 and 30% of the debtors earn below $5,000. They borrow because they cannot make ends meet. And many years ago, when there was a no minimum statutory minimum wage, no transport subsidies, or the proposed low-income subsidy. That's why they had to take out loans. And at the same time, there was no wage increase. So they have no savings to pay off the debt. The debt snowballed. They are not people who we commonly refer to as gamblers, or they are chronic irresponsible people. These debtors are responsible people. We help them to restructure their debts to improve their situation. Over the years, we have helped a lot of people by reducing the number of bankruptcy cases. And over the years, people have been overdrafting. If you ask them to pay about $10,000, including all the fees, it's difficult for them. Normally, it takes them months or even years to get the $10,000 to file for bankruptcy. So in many cases we have encountered, when they are trying to raise the funds to file for petition, they are harassed by debt collectors. We've heard cases of suicide, and there may be a domestic violence or conflicts in the family, and it also causes emotional instability. If you want to help this group of people, well, the administration has been talking about poverty alleviation. If there is a mechanism to help to lift them out of their plights, this will give them some peace of mind and to help them pick up the pieces and move on. We have two options, two proposals. First, to pay the fees in one go, or do it by installments. First, they have to pay half of the fees, and then over the period of 1 to 2 years, put in the remaining fees in a designated account. And every year when they are having their case reviewed, they will have to produce evidence or deposit slips to prove that they have been paying. And if they cannot make good their payment, then the bankruptcy period will be extended. This will be a relief to them. And for those who are in extreme difficulty, say for example those over 65 or people with disabilities that have got medical certificates, or the unemployed, chronic people with chronic illnesses, my proposals will not help them. So would you consider reducing the amount to about $6,500 so that they will be given a way out? They are not pushed to a corner. For the rest, you can charge them the normal amount. No one wants to be bankrupt, because there is a stigmatization, and that there will be impact of their credit rating, their image, reputation, and they will have their promotional prospects taken away. So no one wants to be bankrupt, and this will not be abused. We hope that before they file for petition, well, you see there are overseas practices providing services, say for example employment services like that we provide by organizations to help them, to counsel them and to help them tie them over their financial difficulties. And as a result, there will be a reduction of bad debt, and there will be less poor people. And these people will be given a chance to start a new life as soon as possible. Next, Mr. Kwong. Good afternoon, everyone. My name is Kwong. I am a member of the concerned group. I benefited from the concerned group. And I know about the downward revision of fees. I would like to share with you how we debtors feel. I hope members will understand that when we're trying to come up with the funds to file for petition, we have encountered a lot of difficulties. We cannot make ends meet. And on top of that, we have to come up with a large amount to file for bankruptcy. I hope this subcommittee will allow us to come up with the money by installment. Before we come up with the fees, we have nowhere to go. Let me share with you a number of cases. There is a lady who lives with her son. Her husband was in debt. She wanted to help her husband to clear the debt and borrowed $100,000 from the bank. However, the husband disappeared. The lady could not locate the husband. In the end, the bank loan was taken up by the woman. She earned little. She was done by the bank. She cannot live in peace. She lives in fear. Her family and friends were harassed. It's very difficult for her to come up with the funds to file for bankruptcy. The second case, an elderly person with a son who is 30 years old, suffering from mental illness. They live in a PRH, public housing unit. The son was asked to borrow a loan of $80,000 for a friend. This elderly lady is living on her retirement funds and the old age allowance. On top of that, the disability allowance of the son. Altogether, there is only $5,000 or so. It's not enough to pay the debt. Debt collecting companies harass them by phone, harass them and their family members. They do not have the means to make repayment. The younger sister of the elderly lady was harassed too. And the families and friends, fearing for their safety, come up with over $9,000 to help the elderly lady file for bankruptcy.
And then there was this member who worked in a trading company as a general worker. Because of some urgent need, he borrowed $100,000. And in the course of repayment, it became unaffordable. And Caritas Center helped this person with a restructure plan, and because of the introduction of the statutory minimum wage, that person was laid off by the company, and some $40,000 was paid as a redundancy payment. The money, well, was used to repay the debt. I want the subcommittee to do something to help the grassroots to petition for bankruptcy by reducing the fees payable so that these people can see a future for themselves and their family. Next, we have ICPA.
The opportunity to speak today. My name is Bruno Arboit, and I'm speaking today in my capacity as Chairman of the Hong Kong Institute of Certified Public Accountants, Restructuring and Insolvency Faculty Executive Committee. The committee represents insolvency practitioners and other professionals, both accountants and lawyers, working in the insolvency field. The Institute has already made a written submission to the subcommittee on the proposed changes, and so given the limited time available today, I only intend to very briefly summarise this submission. Essentially, we have no objection to the majority of the proposed amendments to various fees and charges subject to the following. First of all, in relation to the petitioner's deposit, we do not see a need to change the amount. However, we do appreciate that in relation to personal bankruptcies, there are socio-economic issues involved, and accordingly the government may wish to consider other options, solutions, such as waiving the deposit altogether in specific circumstances. The second item I'd like to address is the company's fees and percentages order, Table A, Item 10, which deals with the fee for proofs of debt. With reference to the proposed reduction from Hong Kong $40 to $35 in the fee payable by creditors for the filing of proofs of debt, we are of the view that the consideration should be given to abolishing this fee completely. Our reasoning is that it is already a relatively small amount, which can be administratively burdensome to handle both for the official receiver and insolvency practitioners, and reducing it further would not solve this problem. The fee also particularly disadvantages creditors of Hong Kong liquidations situated in foreign jurisdictions. For a foreign creditor to pay the Hong Kong $40 filing fee, it is both expensive in that it may cost more to obtain a bank draft than the value of the draft itself, and it is also time-consuming. The third issue I'd like to deal with is the company's fees and percentages order, Table B, Item 1, that deals with the ad valorem fee. We believe that the proposal to reduce the realisation fees in company winding up in certain circumstances, particularly where the official receiver acts as liquidator or provisional liquidator, will not have a significant impact, as the official receiver now only rarely acts as provisional liquidator or liquidator. Generally, in compulsory liquidations, either private sector practitioners are directly appointed or, through different administrative schemes, the official receiver's office contracts out insolvency work to private practitioners. In this regard, the realisation fee or ad valorem fee under Table B, Item 1, is considerably more significant both to creditors and to the official receiver's office. Our concern is that in the case of large-scale corporate insolvencies, which are regular, albeit not frequent occurrences, the graduated and uncapped ad valorem fee can result in windfall amounts that bear little relationship to the work performed by the official receiver's office and which are at the expense of the general body of creditors. While specific applications may be made by the liquidators to have fees reduced or waived in these circumstances, such applications are not always successful. We note that the equivalent fees in the United Kingdom are capped at a maximum under the law, and we would suggest that a similar approach be considered in Hong Kong. Finally, I'd like to deal with the Companies Ordinance Section 295. While not part of the subsidiary legislation currently under discussion, we would also like to draw the Subcommittee's attention to Section 295 of the Companies Ordinance. Under this section, monies which, under Section 202 of the Ordinance, private sector liquidators must pay into the company's liquidation account may be invested on fixed deposit or deposit at call. Pursuant to Section 295, subsection 4, out of the interest paid, 1.5% per annum of the money invested must be paid to the Official Receiver's Office. In the low interest environment that has prevailed over the past several years, this provision effectively means that little or no interest on the sums invested is paid to the credit of the general body of creditors. We consider that this provision should be amended so that the interest paid to the credit of the Official Receiver's Office is expressed as a certain fraction of the total interest paid on the investment. Thank you very much.
Thank you. 跟住嚟呢，就我請我哋
Next, may I invite the administration to provide a response? Do we have, is it Ms. Wong or who would like to provide a response? Let me say something first. With regard to the suggestions from Caritas, we've already provided supplementary written information in response to those proposals. In the first meeting, in the previous meeting, we said that in respect of individuals' cases, whether we were asked to consider adjusting the amount of deposits. We have duly considered this. At present, the fees and charges proposed, once implemented, would result in 100% cost recovery on the part of our ORO. If we reduce the fees and charges for certain applicants, that would mean that the taxpayer would have to subsidize the cost. And this is not really proper as a matter of principle, because that would mean taxpayers would be subsidizing bankrupt people. These people, when they file for bankruptcy, they may have financial difficulties in various forms. Or even if we provide for some reduction for certain people in certain circumstances, that may not be considered fair. And we have also considered overseas practice, as suggested by Caritas. And they do not actually provide individually based waiver or reduction.
A submission. First of all, I won't repeat what has been said about the petitioner's deposit. That's clear enough. As regards the $40 proof of debt, that $40 ought to be $35. Not only covers our administrative costs of looking at the proof of debt, assessing whether it's a proper proof of debt. So we do have to charge for it. It's very minor, I understand, but we do have administrative costs to cover. As regards the avalon fee, I do agree that we do, as official receiver, we don't do any of the liquidation anymore. But insofar as the realization of $170 is relevant for the bankruptcy side, we have had cases where we have levied a substantial amount of the realization fee, and those are the cases will benefit from the $170 now we are proposing. As regards the avalon fee that you want to, the avalon fee under table B4, at the moment we have got paragraph 9 of the company's fees and percentages order, which allows the court to give a discount or assess the amount that has been charged on the avalon fee on the application of the official receiver. Under this section, we have not had an application so far, but therefore I wouldn't say that there has not been any successful cases to date. As regards the company's ordinance, section 295, you rightly point out this is not the one of the issues today. At the moment, because of the low interest rate, we are not even getting the 1.5% on average. But this 1.5% is calculated on the same basis to cover our cost of running the office. That's also included in our costing. Thank you, Chairman.
Okay, 多謝你。跟住落嚟呢就係
Thank you. And now it's time for members to put questions to either the deputations or the administration. Mr. Tang Ka-biu. Chairman, how much time do I have? So far, we haven't received many requests to raise questions, so 5 minutes. In the Financial Affairs panel, although I'm not a member, I said in that panel that many people facing the financial crisis are also facing personal crisis. At one point, we had a high unemployment rate and high suicide rate back in 2003, 2004. One of the major reasons leading to suicide was financial stress. People back then didn't know that even if you want to file for bankruptcy, you had to pay $10,000 first. So some people couldn't cope with that crisis. They just run away, or they had to borrow money in order to file for bankruptcy. And some opted for something even worse, and that is suicide. So I've encountered many such cases in the community. Although the official receiver hasn't really directly responded to all the concerns raised by Caritas, but perhaps I can give some time to the deputations or the concerned group to supplement. But this is the time for members to raise questions, not for the deputations to offer further comments. All right, in that case, let me put a question to the administration. You said it may not be fair for taxpayers to subsidize these people in distress. But what about the Caritas proposal of payment by installments? By installments, that means there's a biggest room for maneuver. The period concerned would be 4 years, and all the fees and charges have to be paid before the bankruptcy is discharged. That may be more humane, that may be more people-oriented. At present, you are overcharging, so by reducing the fees and charges, you achieve 100% cost recovery, but you must have a surplus already. Let's say we ask the applicant to pay $4,000 first, and the rest to be paid within the bankruptcy period. Maybe we can have a compromise solution like that in order not to turn a financial crisis into a personal crisis?
邊位？
Who is to take this question? Well, I'd like to respond to the issue of paying by installment. There will be legal implications because we have to amend the law. When someone has filed for bankruptcy, or someone is declared bankrupt, his assets belongs to the ORO. So the installment belongs to the ORO. It won't go to the pool of asset of the debtor or the deposit. So what if no payment was made over the period of 4 years, and after 4 years the bankruptcy order was lifted? Currently, we don't see it as a feasible proposal. It would be meaningless to try to drag on. Will you further consider the two proposals, or can you come up with maybe a third proposal to address the genuine needs raised? This is a policy issue. So, PAS? Yes. This issue was discussed before. We are now having a discussion about fees. The ORO has all along adopted a cost recovery approach to when setting their fee levels. The Caritas and the Hong Kong ICPA mentioned about alternatives to help debtors, say for example along the lines of social welfare. These may need to be further explored. Well, the policies are formulated by the administration, and the ORO is there to implement these policies, initiatives. So it will be them who should initiate any changes. Now there is a reduction. It's because they were charging too much. They were taking the shirt off of debtors' back. For these people, they don't even have money to file for bankruptcy. Well, if you want to make it feasible to for payment by installment, change the law. No one wants to remain bankrupt. Well, now now there is an upfront payment. So whether the payment is made upfront or later is the same. Well, they can owe the ORO 8,000 or however much. When the bankruptcy is discharged, then the payment will have to be paid off. Otherwise, the bankruptcy order will not be discharged. This is only a technicality. Once you have overcome that hurdle, you'll be able to resolve the problem. Why do you require only an upfront payment and not a payment collected when the bankruptcy order is discharged? But this is a policy issue. I think it should be taken up by the FSTB. You have to be clear about the principle and the policy first. Well, let me supplement what the official receiver said. It's not the case that it cannot be done under the legal framework, but in the normal course, before a petition is filed, they have to pay a deposit to trigger the process, and then they will have to realize the asset, which is distributed equally to the creditors. Well, if the Caritas proposal is adopted, this will run counter to the fairness I've just outlined, and that will not be proper. The principle of the ORO will change. Now, the maximum period the period is 4 years with a maximum extension to 8 years. And if you owe us the deposit and as a result the period is extended, this runs counter to our principle, and there will be difficulties. Can you further expound? I fail to see the difficulties. Maybe it's because of me. As far as I understand, well, as long as the deposit is not paid off, the bankruptcy order will not be discharged. But according to the law, the period is 4 years. The bankruptcy period is 4 years, and if there is a default, then it can be extended to 8 years. Prior to 1998, the bankruptcy period can last throughout your lifetime. It's changed. But if you now say that the deposit is not paid off, say an outstanding amount of several $100s, how long should we extend the bankruptcy period? Then we will be going backwards. The policy of the administration is to help rehabilitation and not to just extend the bankruptcy period. Ms. Ho. In the first meeting, members have heard our concern. That is, for people who are very poor, who have nowhere to go. And when they would like to restructure their debts, they will have to first come up with $8,000. In the last meeting, we're all very open-minded, and we sympathize. We're trying to think for them about how to help these people who are pushed to a corner. But today, in the response paper of the administration to Caritas Family Crisis Support Center, it seems that they have hardened. They don't even consider payment by installment. I think the Caritas proposal is quite mild, only a reduction of $2,000. Last time, we asked for the deposit to be completely waived. Well, for poor families, they have to declare bankrupt maybe just for a small amount of money, less than $10,000, but they have to come up with $8,000 to file for bankruptcy. Well, apart from the fact that they don't want taxpayers to subsidize this group of people, can we think in another way? To think about how to help them to rehabilitate and to restructure their debts. And if they can't come up with the money, they can't even take the first step forward. And that will not be the way out. The ORO may not be able to conduct means tests, but that can be taken up by the SWD, the Social Welfare Department, in particular in cases of poor families where there is little assets. If social workers and the SWD can come up with an assessment, and based on the assessment, the ORO will waive a certain percentage of the deposit or to allow them to pay by installment. I know that I can't ask the ORO to take up the role of a social worker, but they can accept the referral or the recommendation of social workers. Who is to take this? We have liaised with the SWD, and they say that people who have been declared bankrupt can approach them for assistance. Mr. Lu, in the last meeting, you may recall that the HAB and the LWB, the Labor and Welfare Department, and the Home Affairs Bureau and the Labor and Welfare Bureau were asked to help. And in many bankruptcy cases, the services have been provided through their family centers. As far as we know, there are subsidies under the HAB, Home Affairs Bureau. So these are the services provided. What do you mean by the subsidy under the HAB? Can you explain further? We were talking about an assessment and recommendation by social workers or social welfare organizations. And if they say that if you ask them to come up with the deposit, that is simply impossible. And if you accept the recommendation, then it will be a step forward. Ms. Ho? You asked the ORO and the FSTB to answer you about social welfare. It's outside their purview. We can send a letter to the SWD to ask them for explanations. You're talking about different government departments. You can't ask one bureau to answer on behalf of another. Yes, I understand that. This issue was touched on last time. Yes, we did, and we've given them an invitation. And they answer us in writing to turn us down. Perhaps we'll have to try to get them to come to the Home Affairs panel. Yes. Different departments may be involved in subcommittees or bills committee. I condemn departments who refuse to come. Yes, it will be a proper place to condemn them in a panel meeting. But we're here today, and we should be as tolerant as possible. We are here to talk about the reduction of fees. I'm talking about an insufficient reduction. We're not talking about a huge change of policy. Well, we can't ask for more because we're restricted by Article 74 of the Basic Law. Otherwise, I will have asked for more in reduction. Of course, when it comes to these issues, policies will be involved. Mr. Chiang Hin-po, I asked the same question, but from a different perspective. These people are poor to begin with because they have to file for petitions. Well, there may be some fees that are not recovered 100%. Can you just recover, charge them half of it, say $3,000 to $4,000? Are there cases when fees are not fully recovered? I don't know whether there are similar incidents when the administration does not recover full cost. I cannot answer on behalf of the Treasury, but under bankruptcy services, you must understand that this is a long-standing policy. The ORO provides the service. Should we ask taxpayers to subsidize the shortfall? And it's an issue that we need to consider. We think that recovery of 110% of cost is not right. Well, when it comes to file a petition for bankruptcy, it's a personal issue and it should not involve non-related parties, say for example taxpayers. Can I be given some information in an information paper about cases when cost is not fully recovered? And what about cost reduction of the ORO? If cost is driven down, then you won't ask them for as much. If you continue to increase cost and shift the cost onto debtors, is not right. This is a huge setback for debtors, and they need all the help we can give. If there are cases when cost is not fully recovered, let us know, and we can draw reference from it.
I'll try to find if there are relevant statistics. What is covered by $8,650? $8,650. What is covered by this fee? It's a deposit. It doesn't say it covers this or that. Once this is paid, it will be used to meet our expenses. What kind of expenses? Such as doing a land search, company search, gazetto, a notice in the gazette, traveling expenses, agent's fee, not in every case, transportation, a few $1,000s, and one of the major item is a gazetto notice. What's the cost? 4,000 something. The gazetto? No, the estimate is different case by case. What about the remaining 4,000? We have a minimum cost. The cost ourselves is $12,150. The minimum fee is $12,150 in case the ORO is the trustee. And some will be charged by outside trustees. Well, just what I want to say about outside trustees. ORO likes to outsource such work. For example, the outside trustee has to be responsible for the entire 4-year period. So the responsibility of the ORO is delegated to such outside trustees because of keen competition. You pay them something like nothing to 12,000, and you do nothing on your part. For those searches that you mentioned, they are simple and straightforward. Who are doing the real work over the 4 years concerned? Well, it's the outside trustees, but you only pay them 1,000 or so, and so on. You are saying that you can only recover 100% cost if you ask for a deposit of 8,650. I think you're overcharging them. It's not that we can delegate everything through outsourcing. We still have a supervisory responsibility. We have to check accounts and annual statements, and there's a cost. There's a supervisory system there. The work done by the outside trustees over a period of 4 years must be more than what you do in the same period. What do you have to charge these people? $4,000 or so in order to be a supervisor. It depends, really depends on the complexity of the case. Our people have to go out to do case management, and that is a cost on our part. Well, if these trustees do the donkey work at $1,000 or $2,000, and you just take a look and you charge twice that amount, would you say that's unreasonable? Well, we think it's reasonable. Please clarify. I have to declare my interest. My law firm also takes up such trustee work, so I'm one of those doing the donkey work. We charge $1,000 to $2,000 and be responsible for the case for 4 years. The ORO acts like a mailbox whatever complicated work you do, well, you just take a look. The real work is always done by outside trustees. So please don't underpay the outside trustees, and at the same time you charge a high fee, imposing a heavy burden on the debtor. We have 9,000 or 10,000 cases annually. We only outsource 25% of those. So we are doing 75% of those. In that case, you should outsource all the remaining 75% at $1,000 or $2,000, and you can charge less. So you should outsource the remaining 75% of cases to those who are really efficient. Can you reduce costs to do that? We believe that 25% is the reasonable portion for outsourcing. Dr. Liu Wei-Kok. Actually, the fees are not 100% pegged to costs. If we want to change this, a lot of other things will have to be changed. You may have to assess the cost of each and every case, and a lot of auditing or assessment may be required, pushing the costs up. I know that there are people who are already poor who find it difficult to cope, and sometimes very little is required on the part of the ORO because the bankrupt doesn't have any real estate or other assets, and there's little searching to do. But poverty and bankruptcy are two different things. It's not necessarily true that poor people would tend to become bankrupt. But of course, some of the bankrupt people might be very active previously, economically active previously. Maybe for some special reasons that happen to their family members that drag into this and become bankrupt. If we are to change the fee structure, then we are really expanding the scope of discussions into a very large area. If there are worthy cases that assistance should be offered, perhaps we should look to see if there's a safety net instead of changing the mechanism, the arrangement. If a family in such a situation and they need assistance, well, I believe the SWD, the Social Welfare Department, may be able to offer help. But if we want to pack this or link this with fees and charges for bankruptcy petition, then it's difficult. It's difficult to proceed. As I understand it, why is it not possible to allow payment by installments? Because once this is started, whatever payment the bankrupt person pays must be shared by all creditors. It cannot be just for the government. So that's why the ORO says it's not feasible, and you cannot extend the bankruptcy period indefinitely. So although we are sympathetic, we have to be objective. These proposals are for fee reductions, and we need to look at these proposals directly. I just don't think it's possible to solve all those related social problems here. Thank you. Thank you for answering the question on my behalf. Actually, some of the issues raised should better be discussed and addressed in our panel meetings. But as chairman of this subcommittee, I have tried to be as relaxed and generous as possible to offer more opportunities for members to speak. Mr. Sin Chung Gai, I think we are talking about technical issues here. Upfront payment or payment afterwards are both possible. It's a question of expectations of the community, or the question of bureaucrats reluctant to change. You want to promote rehabilitation, but the threshold of gaining entry is too high. If you make a little bit of change, of course I understand you may have to amend the law to do it. For this particular resolution, it's just about reducing the fees, because the principle is to recover costs. And now you have deputations here telling you some problems that they have faced. They have handled so many cases, and they have learned from real experience. So shouldn't we consider making some changes? If not now, then when? And what about FSTB? Is there room for change? Well, I understand that in 1998, the bankruptcy period was shortened to 8 years at most, instead of for life. And now the Caritas has handled so many cases. Maybe it's time to review the situation after the last change introduced more than 10 years ago. Maybe I didn't make myself clear. It's a question not about the legislation, but the bankruptcy regime we have put in place. Maybe the official receiver can supplement. If someone becomes bankrupt, then afterwards he makes certain payment. That money should go to all creditors, not to the government. The debt owed to the government is incurred after the bankruptcy. So it's the so-called second bankruptcy. So if the bankrupt person pays anything, the money should go to creditors first. Some of them are doing it now. Well, we have to urge the bankrupt person to make payment. There may be a need to meet them, to interview them. So the debt should be looked at like this.
Yes, it was mentioned that well, some of the money will go to the government first. You may need to change the framework if you collect the payment, perhaps 10%, and after all debts have been paid off, at the exit point, you need to pay the balance of the deposit. It's a structural change, and you can consider it. I don't see how it is infeasible. Well, actually, for 4 years, there may be the case that only a small amount is paid off. So in the end, the money should not go to us. And there is also legal implications. What if that person dies? We have to consider all cases. I see that there are difficulties, not legislation in general, but the one related to bankruptcy. Ms. Kwok, you would like to say something? Well, thank you for this. For the second chance to share with you my view, the views of frontline officers. Well, NGOs are humble. I do appreciate the ORO in their taking the initiative to revise the fees, and I thank members for their concern and their support to our services. I'd like to say a few things first. From the figures of the ORO, majority of the cases involve people who earn less than $10,000, 70% of them. So they are not well off, and as a result, they cannot make ends meet. I don't know the law. I don't know whether you can consider this in terms of policies. We're talking about installments. Not all people filing for bankruptcy are allowed to pay by installment, or they may not even choose to do so. It is only for those people who cannot come up with the entire amount. This will be an alternative for them. We ask the ORO not to see it as an outstanding payment, but a payment paid by installment. We've made a calculation. Say, for example, for over 2 years, they save $200. This is only a payment towards services rendered. Even when there is no waiver or reduction, there is still at least this mechanism for them to pay by installment. I won't touch on social welfare because it's even more complicated and difficult. If you want to involve the social workers, well, I have had 11 years of experience. I know about the issue because I have plunged myself into it. And we are already snowed under, and if you ask us to do more to give assessments and things like that, well, we simply can't cope. And debtors are in urgent need. You can't ask them to wait for an assessment. We're only asking for a simple mechanism to help them. You should not need any vetting of your means to pay by installment. Well, when it comes to reduction, say for example, you have to show that you're over 65 and you have medical certificates showing that you are suffering from disability. I have considered all these for the ORO. I know that you encounter difficulties. That's why I thought for you, so that there will not be additional administrative cost incurred. If you want to involve social workers, well, as far as I know, any more time and manpower spent is paid by taxpayers. For low-income earners, when it comes to housing, education, they receive subsidies from taxpayers. So why can't this be resolved by policies in this regard? Or I'd like to ask, from 1998 to now, it's been 16 years. How many bankruptcy cases are there? Over the period of 16 years, how many cases of bankruptcy? Sorry, can I have some time?
I
don't have a calculator with me. The peak is 2002 and 2003. Over the period of 2 years, 50,000 or so, and thereafter over 10,000 cases. So about 100,000 or so, ballpark figure. Mr. Sin Chung Kai mentioned that the Caritas Center has dealt with over 100,000 cases. Ms. Kwok. Now, we mentioned that we have provided services to over 60,000 cases, but not all of them are bankruptcy cases. We try to help them with restructuring of debts. There is a free service providing restructure of debts to them. Such services is usually provided at a high fees in the private sector. We have made great contributions to the entire society. Members have heard the views of Caritas Family Crisis Support Center and the Hong Kong ICPA. The support center expressed views on policies. That may be different from the scope of this subcommittee. I suggest that when it comes to policies, it should be dealt with by the panel. The Hong Kong ICPA has given views and suggestions related to fees. Under the basic law, the LegCo has no power to amend this unless the committee stage amendment is moved by the administration. Can the administration respond to what the Hong Kong ICPA has submitted today? Any response? Well, just now the OR has already responded. If necessary, I can put them in black and white. Yes, we've heard the initial reply. It seems that the administration turns down the ICPA's suggestions. The OR said that some of them are not related. No, the last one is not related to this. What about the earlier ones? The administration's view is to keep your original proposal. I hope that you will give us a written reply to make things clear. Members, any other views? If not, we have time to do the clause by clause. Deputations. If you wish, you may remain. If you are otherwise engaged, you may leave. Now we move on to clause by clause. Who is to take us through the clause by clause, the OR, or perhaps I will go through the amendments. There are 4 subsidiary legislations, and I'll deal with them one by one. First, Bankruptcy Amendment Rules 2013. There are only two clauses. First, in the preamble. I'm not going to go into details. And the second one is something we have spoken about. The bankruptcy petitioner will have to pay a deposit. We propose to reduce it from 8,650 to 8,000. If the petition is filed by a creditor, it's reduced from 12,150 to 11,250. That is in clause 2. Sorry, Mr. Lu, what is the number of the document you're referring to? Are you referring to CB bracket 11566/12 to 13 bracket 01? Oh no. Let us all use the marked up version. Yes, it would be easier if we're all looking at the same document. We have had a lot of discussions about policies. Let me repeat. The second clause of bankruptcy rule is section 52, the first page of the marked up version, in relation to the deposit by petitioner. Is reduced from 8,650 to 8,000. And in relation to creditor's petition, currently the fees is set as the deposit is set as 12,150, will be reduced to 11,250. The next page is the corresponding amendment in English, and then the next subsidiary legislation is Bankruptcy Fees and Percentages Amendment Order 2013. The first one is a preamble, and the second clause, subclause 1, is Schedule A, Item 4. Proof of debt above $250. A fee of $40 will have to be paid. It will be reduced to $35. And just now the ICPA mentioned this. Subclause 2 of 2 is Table A under 6B. If the bankruptcy order is discharged early, each creditor will have to be notified. The fees is reduced from $35 to $28, back to the 1997 level. Subclause 3 under Table A refers to Item 10. It's in relation to application to the official receiver for payment of money out of the bankruptcy estate account. For each application, a fee of $85 is to be paid, and we propose to reduce it to $80. Subclause 4 refers to Item 11B of Table A. This is in relation to payment of money out of bankruptcy estate account. The ceiling of fees was set as $45,000, is now revised downwards to $37,500.
Please continue. Then section 2, bracket 6, is about a change to Table A, Item 17. If you go to the ORT, sorry, it's Item 16. If you want to check in the official receiver's office for bankruptcy petition, the charge will be reduced from the existing $85 to $80. Then bracket 6 of section 2 is about item 17, application by a member of the public to the OR for issue of a non-bankruptcy certificate for a person. The fee will be reduced from $205 to $190. And then bracket 7, in relation to Table A, item 18, is for insertion in the Gazette of a notice relating to bankruptcy. The fee is going to be reduced from $355 to $330. Please continue. We're now on Table B. It's a realization fee. We are going to change the basis of charging. At present, for each case, it's a fee of 10%. And we are going to change the charging arrangement to reflect the change in ORO's work process. So every time when the OR realize certain assets, then there will be a charge of $170 each time. It's in 1A on the right hand side. And 210, item Table B, paragraph 4. If the OR acts as a provisional trustee, the fee will be reduced from the existing $1,100 to $1,000. If the official receiver acting as an interim trustee beyond 14 days, there will be a fee of $1,100 per day, and this will be reduced to $1,000 per day. Bracket 11, Table B 5A, in relation to OR issuing notice to creditors and certain expenses involving stationery, the fee is to be reduced from $670 to $620. If there are more than 10 creditors, then another $670 will be charged, and this again will be reduced to $620. And bracket 13 is paragraph 6 of Table B, and that is the charge is $1,560 when the official receiver calls a meeting at the request of creditors. This will be reduced to $1,440. And then bracket 14, in relation to paragraph 11, there's a minimum fee to be paid to the OR, $12,150, and this will be reduced to $11,250. So that's in relation to bankruptcy, the bylaw. And now let's move on to companies ordinance. It's entitled Companies, Fees and Percentage Order. It's the paper CB1 1566 1213 bracket 02 and 03. The first change, 1A, item 1A. The fee payable for inspection of a copy of the liquidator's account, it will be reduced from $12 to $11. And then item 3, on an application by a liquidator to the official receiver for a special bank account, fee is payable is $390 at present, and it will be reduced to $360. That is in relation to Section 2, Bracket 3 of the order. And Section 2, Bracket 4 is about 4A, item 4A of Table A. If the liquidator acts as a committee of inspection, the fee to be paid is $390 and will be reduced to $360. And item 5, and that is a 3 bracket 5. If there's a lapse check and the check has to be reissued after 6 months, then a fee of $60 will have to be paid. The fee will be reduced to $55. Oh, I missed the 4A. All right. And now it's 6B, item 6B of Table A, Schedule 3. The total fees taken in respect of undistributed funds or balances shall not exceed $45,000 in each liquidation, and this is to be reduced to $37,500, and that Section 2.7 is item 7 of Table A. For insertion in the Gazette of a notice relating to a company which is being wound up by the court, the fee is $355 and it will be reduced to $330. And bracket A is about item 8. If a member of the public want to conduct a search whether there's a winding up petition presented against a company, then a fee of $85 is payable. It will be reduced to $80. And then a bracket 9 of the order in relation to item 10 of the same schedule. The ICPA mentioned this, and that is on proof of debt above $250, a fee of $40 is payable. We propose to reduce this to $35. And Section 2, bracket 11. There's a corresponding provision in the Bankruptcy Ordinance, and that is in relation to realizations or liquidation under the company's ordinance. We use a percentage, 10%, as the charging basis. On the right-hand side, we list the new item 4, bracket 2. So at present is 10%, and in the future, then $170 on every payment made into the company's liquidation account. And bracket 5 and bracket 6 are consequential amendments, and they have nothing to do with fees or policies. So there's bracket 12, bracket 13, bracket 14, the minimum fee. If the official receiver acts as liquidator of the company, then the minimum fee to be payable is $12,150. This is going to be reduced to $11,250. The last change is about companies winding up amendment rules. It's CB1 1566 12 13 bracket 04. There's only one amendment in Rule 22A bracket 1. If you present a petition to the OR, you have to pay a deposit of $12,150, and we propose to reduce it to $11,250. That's in Section 1, bracket 2 of the amendment rules. And also, in the last page, in relation to the Section 3, that is Rule 117. If the OR acts as a liquidator, then for the purpose of convening meetings of creditors and other costs, a fee of $1,550 is payable. Is going to be reduced to $1,440. So these are the proposed amendments. Members' comments are welcome. Members, any questions concerning the cross-by-cross examination? If not, then it's done. Today we have scrutinized the the Chinese version. Can I ask the legal advisor to follow up relevant matters in the English version after the meeting? And if there are no other business, then we can pause here. Any CSA from the government? No. A reminder for members, if we want to move our amendments, if members want to move their own amendments, have you decided when to do this in the council? On the 15th of October, the notice of the resolutions will be given to LegCo by the Secretary. According to the Secretariat, the earliest for the House Committee to discuss the Subcommittee's report will be on the 18th. If there are no problems on the 18th, then on the 30th, the Secretary would introduce the amendments in the form of resolutions to the Council. So 18 for the House Committee is the 18th, Council meeting the 30th, and what is the deadline for amendments? The 23rd of October. If members want to move amendments, the deadline is to do this before the 23rd of October.
好啦，咁
Okay. There is no need for another meeting. We have completed our work and it's not yet 4:30. Thank you. Meeting adjourned.